Hi, this is Marcus Power. I will be reviewing the Dallas Cowboys Cheerleaders Incorporated versus Pussycat Cinema Limited case. This case was in 1979 was taken to the Southern New York District Court. The injunction was granted for the Dallas Cowboys Cheerleaders, the plaintiff, to stop Pussycat Cinema Limited from using their uniforms that they had trademarked, and it was appealed to the U.S. District Court by the defendant in order to try to lift the injunction. The plaintiff was the Dallas Cowboys Cheerleaders Incorporated, and the facts of their side were that they had a uniform trademark. They had a distinct, well-known design. The defendant was Pussycat Cinema Limited, and they were appealing a temporary injunction placed by the Southern New York District Court. The plaintiff argued that there was confusion with possible involvement or sponsorship or allowing the defendant to use their trademark, and that could create problems with their followers and the public view of their company. They also believed it would be dilution, that someone else using the same trademarked uniform would be causing other issues, confusing, again, the brand. The argument from the defendant was they wanted to check to make sure there was a valid trademark because it was a cheerleading uniform that was being used, and the uniform itself being a functional part of the activity could not be trademarked. However, the court did confirm that there was a trademark, that it was the distinct design and cosmetic aspect of the uniform that the Dallas Cowboys cheerleaders used was the reason that the issue was at hand. The argument from the defendant were also that there was no chance for confusion, that the distinct difference in the industry was part of the distinction apart from it, that it would make a difference between what the Cowboys cheerleaders did and what the defendant's company does. They also stated fair use could come into play, that they could bypass the trademark infringements by using the uniforms in what they deemed art and industry. The court findings were that there was no unconstitutional restraint on the defendant's business. The plaintiff did have a valid trademark that was being infringed on, and they did in fact affirm the district court's decision that there would be a temporary injunction granted and that there was nothing wrong with what the previous court did. The implications for athletic directors would be basically just avoid using copyrighted or trademarked material without approval to do so. One of the cases that I found was Mizzou has actually sent letters to a high school in Arkansas asking them to stop using what they deem to be a very similar logo. It's a little bit different colored, a little bit detail different, but they've started the legal process. The school has said that they will continue to use it, but it could cost them somewhere between $10,000 and $50,000 in legal fees by doing so. So as an AD, an administrator, anything of that nature, try to use something new. If you're going to use something that someone else has trademarked, try to get approval for that first. That way you're not doing anything illegal. And then, of course, with the school district, if you need to communicate with a legal counsel first, make sure you're not infringing on anything, get their advice, what the next best thing to do is. All right, and that's all I have for the case of Dallas Cowboys Cheerleaders Incorporated versus Pussycat Cinema Limited. Thank you.